and their recent actions against firearms manufacturers, federal firearms licenses, or FFLs.
In the United States, fentanyl is the #1 killer of Americans in the United States, and they have no problem
doing. If we can't save all lives, it's not worth saving a single life. Well, I suppose that
medicine was the first school of medicine in the United States to allow students with DACA status
bans for 18 to 20-year-old adults guns that are in common use. It bans
process rights as every other American before they lose their constitutional rights.
Yes.
Yes.
The fact that the authorities in New York despise arms and are attempting to bring an end to the Second Amendment is already a serious problem. Supreme Court overturns New York law. The Supreme Court concluded that Americans have a wide-ranging right to arm themselves in public, overturning a New York law that had severe restrictions on carrying arms outside the home and causing a flurry of activity in other states that have similar laws. The judgment would require 5 states, California, Hawaii, Maryland, Massachusetts, and New Jersey, which is home to 1/5 of all Americans, to rewrite their laws, and is expected to spark a surge of litigation trying to ease current state and federal limitations. The decision was made in response to the mass casualty incidents that occurred in Buffalo and Uvalde, Texas. It was also made on the same day that the Senate approved new arm control legislation that would strengthen background checks for people looking to purchase arms between the ages of 18 and 21, give states incentives to enact so-called red flag laws, and tighten the federal ban on domestic offenders being allowed to purchase arms. It was the most important arm legislation-related action by Congress in almost 3 decades. The 6-3 ruling once again demonstrated the influence of the 6 conservative justices, who all voted to overturn the New York statute in determining the social agenda for the country. 3 liberal judges on the panel disagreed. For the majority, Justice Clarence Thomas argued that the Second Amendment safeguards a person's right to carry a handarm for self-defense outside the home. According to Justice Thomas, states can continue to ban arms in some places, such as government buildings and schools, but the decision left it unclear exactly where such restrictions might be permitted. Governor Kathy Hochul of New York promised to call the legislature back together as soon as next month to pass new legislation that might allow the state to keep current laws shortly after the decision was made. Additionally, Democratic Maryland senators said they will alter the legislation to withstand anticipated court challenges. "We already have a serious armed crime epidemic," Ms. Hochul declared. "This fire doesn't need more fuel," someone said. The dispute centered on so-called May issue laws, which grant government authorities a great deal of latitude in granting arm licenses. Justice Brett M. Kavanaugh and Chief Justice John G. Roberts, Jr. argued in a concurring opinion that shall issue statutes employed objective standards and were presumptively lawful, appearing to limit the scope of the majority ruling. He stated that states were often free to impose fingerprinting, a background check, a mental health records check, and training in arms handling and in laws regarding the use of force. Justice Kavanaugh also cited a lot of the court's District of Columbia v. Heller decision from 2008, which seemed to support additional limitations. President Biden criticized the decision and expressed his deep disappointment. "This contradicts both common sense and the Constitution and should deeply trouble us all," he continued. Advocates for arm rights applauded the decision. "The court has made clear that the Second Amendment right to bear arms is not limited to the home," said Larry Keene, a top executive with the National Shooting Sports Foundation, the leading trade association for the arms industry. That it is the responsibility of the government to defend restrictions, not of the individual, who must defend the necessity to exercise their rights before the government. On Wall Street, the share prices of arm makers increased, with Smith & Wesson rising by more than 9%. Arm control advocate Jonathan Lowy argued that the choice was a serious error. The Supreme Court invented a supposed right to carry virtually anywhere loaded arms to potentially slay other people, he claimed in a statement. 2 men filed a lawsuit after being refused the licenses they sought in New York, claiming that the state makes it virtually impossible for the ordinary law-abiding citizen to obtain a license. Supreme Court's ruling on the Second Amendment. State officials informed the Supreme Court that Robert Nash and Brandon Koch were permitted to carry arms for target practice and hunting outside of crowded areas, and that Mr. Koch was also permitted to carry an arm to and from work. According to Justice Thomas, people may not be asked to give the government an explanation of why they were attempting to exercise a constitutional right. He stated, "We are not aware of any other constitutional right where a person may exercise only after demonstrating to government officers some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion," he continued. In terms of a defendant's right to face off against the witnesses who are testifying against him, that is not how the Sixth Amendment operates. And that's not how the Second Amendment operates when it comes to carrying an arm in public for self-defense. According to the majority opinion's general criterion, which is based on past evaluations, courts must now evaluate restrictions on arm rights. The government must show that the regulation is in keeping with the historical tradition of arm regulation in this country.
Was made to count human beings as 2/3 of one person if they had more melanin.
And the recent actions against firearms manufacturers, federal firearms licenses, or FFLs.
When it is fired. So it just doesn't make a whole lot of sense. And I'm sure Mr. Bosco.
Not liking a law isn't a reason for ATF not to.
Well, Mr. Wilcox, there's no law. Congress didn't pass it.
Medicine was the first school of medicine in the United States to allow students with DACA status.
In the United States, fentanyl is the #1 killer of Americans in the United States, and they have no problem.
Justice Thomas disregarded the criterion applied by the majority of lower courts, which assessed whether the statute served a substantial government interest in favor of placing a strong emphasis on history. He agreed that the court's new requirement for a historical investigation would not always be simple. Justice Thomas stated that states were still able to prohibit arms in sensitive locations, citing a few examples such as courts, legislatures, schools, and public buildings. He did, however, issue a warning, defining the category of sensitive places simply to all public gathering places that are not isolated from law enforcement defines the category of sensitive places far too broadly. Justice Stephen G. Breyer dissented, claiming that the majority's instructions were insufficient and left the parameters of the court's decision unclear. What about the subways, bars, theaters, and sporting venues? Breyer, a judge, wrote, "The court says, the court does not say." He claimed that the court's almost exclusive reliance on history was not only unnecessary, but also profoundly unrealistic. It imposes a task that judges cannot easily accomplish on the lower courts. He claimed that judges are not historians. Legal experts typically have little experience answering contested historical questions or applying those answers to resolve contemporary problems, he wrote. He continued, laws addressing repeating crossbows, lance gaze, dirks, dags, scythes, stilleters, and other ancient arms will be of little help to courts confronting modern problems.
It's important that our Constitution does have a Second Amendment.
I think that all the amendments are important. It's very hard to start comparing.
Bans for 18 to 20-year-old adults guns that are in common use. It bans
to be stopped. Now, at the same time, this committee, the Senate Committee, Senate Veterans Affairs Committee have been
doing. If we can't save all lives, it's not worth saving a single life. Well, I suppose that
they're in jail, they can't be in communities shooting people. Do you agree with that statement?
We work very closely with DC police.
Process rights as every other American before they lose their constitutional right.
Yes.
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 The Supreme Court acknowledged a person's right to retain arms in their house for self-defense in the Heller case. On the subject of the Second Amendment's rights since then, it has been essentially mute. In fact, the court rejected innumerable appeals in Second Amendment issues for many years. Lower courts usually upheld arm control laws in the meantime. As the court's membership drifted to the right in recent years, it became less reluctant to hear Second Amendment disputes. Justices Kavanaugh, Neil M. Gorsuch, and Amy Coney Barrett are former President Donald J. Trump's 3 appointees, and they have all indicated support for armed rights. And the most conservative justices on the Supreme Court have long criticized the court for refusing to consider the Second Amendment's definition and application. Justice Thomas stated in a 2017 article that he has noticed a distressing trend, the treatment of the Second Amendment as a disfavored right. The provisions of the Second Amendment might seem antiquated and superfluous to those of us who work in marbled halls, guarded constantly by a vigilant and dedicated police force, Justice Thomas said. The right to keep and carry arms for self-defense was explicitly reserved for all Americans by the framers, however. assessing the impact. A century-old New York statute that practically prohibited anyone from carrying arms in the state was invalidated by the U.S. Supreme Court last summer. According to a 6-3 decision in the case of New York State Rifle and Pistol Association, Inc. versus Bruin, applicants for concealed carry permits do not need to provide justification. Although proponents of arm rights praised the ruling as appropriate and long overdue, several observers labeled Bruin as a danger to public safety. In the words of Michael Waldman, president and CEO of the Brennan Center for Justice, the Supreme Court's ruling striking down a New York arm law isn't just the most significant ruling on the Second Amendment in a dozen years, it may be the most significant and most dangerous such ruling in the nation's history. The editorial staff of the New York Times had a similar sentiment when they characterized the choice as being profoundly at odds with precedent and the dangers that American communities face today. Almost 6 months later, the crime wave that those ominous predictions predicted has not yet happened, and in fact, not only has New York dodged the flood of armed crime some had predicted, but incidents are also on the down. In the final 5 NYPD reports of the year, there were fewer incidents in the months after Bruin compared to 2021. Given the complex nature of crime trends, the widespread public outrage sparked by high-profile incidents in early 2022, and the subsequent legislative initiatives aimed at patching what has long been, and in many ways still is, an imperfect framework for regulating access to arms, it is necessary to understand why Bruin has not caused a wave of incidents. Setting up Bruin. The validity of the 1911 Sullivan Act, a state statute that demanded a stringent licensing structure for hand arms, was at the heart of the Bruin case. In order to be granted a hand arm license, New Yorkers had to prove that they had a specific need. State court's interpretation of the requirement was that the plaintiff had to demonstrate a special need for self-protection distinguishable from that of the general community. Celebrities, for example, who posed a particularly high risk to their safety in public, were historically given preference in this application process. As a result, much to the chagrin of pro-arm rights organizations, concealed carry permits were granted to people like former President Donald Trump, Bill Cosby, Howard Stern, and Nelson Rockefeller. In this regard, New York City was what's known as a may-issue jurisdiction under Sullivan. If certain requirements are met, the licensing authority, in this case the New York City Police Department, may grant a license to an applicant. In shall-issue states, licensing agencies are required to make licenses available to anyone who satisfies the minimal conditions of being of legal age and clearing a criminal background check.
Mr. Chairman, Mr. Director, in 2012, John Spencer, Chief of Firearms Technology Branch.
I thank the gentleman for yielding. Mr. Dettelbach, the pistol brace is an accessory, right?
Whether intentional or unintentional, of Biden administration officials and anti-gun advocates and even the president himself.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
The New York State Rifle and Pistol Association, along with unsuccessful concealed carry applicants Robert Nash and Brandon Koch, were the plaintiffs in Bruin. They claimed that the Sullivan Act violated the Second Amendment by unreasonably erecting obstacles to arm ownership. In order to prevent applications from being denied due to a lack of a good enough justification or proper cause for carrying an arm in public, they wanted to change the licensing framework. Nash had applied for a license, citing a string of burglaries that had occurred recently in his neighborhood, but the NYPD determined that this evidence did not properly distinguish Nash's level of danger from that of the typical citizen. Before Bruin, the U.S. Supreme Court had rendered 2 significant seminal rulings on the topic of arm ownership in private homes: District of Columbia v. Heller and McDonald v. City of Chicago. In the Heller decision, the court decided that an individual's right to own arms, regardless of participation in a state militia, as well as their right to employ arms, including hand ones, for domestic self-defense, are both guaranteed by the Second Amendment. And in McDonald, the court confirmed that the Due Process Clause of the 14th Amendment, which forbids states from denying people their life, liberty, or property without due process of law, incorporates the individual right to keep and bear arms, guaranteed by the Second Amendment. Heller and McDonald were essential predicates for Bruin because they established that the Second Amendment protected an individual's right to own and carry arms, said Harvard Law School professor Mark Tushnet. Technically, McDonald concluded that state governments were subject to the same obligation under the 14th Amendment as the federal government which serves as the legal basis for District of Columbia legislation to protect an individual's right to bear arms. Tushnet asserts that the Sullivan's Act precision was a contributing factor in its longevity of more than a century. The Sullivan Act's legal foundation was less vulnerable to attacks from the pro-arm rights movement because it did not expressly prohibit arms, in contrast to the laws at the center of Heller and MacDonald. Until the early 2000s, the chances of a successful challenge were really low, and the arm rights groups who were developing a strategy decided that it made sense to proceed step by step, he added. Therefore, they pursued outright prohibitions on common citizens' possession in Heller and MacDonald, intending to pursue more specific regulations, may issue legislation like the Sullivan Act and concealed carry laws next. Bruen extended the protections provided by the Second Amendment from the private realm to the public one. Justice Clarence Thomas of the U.S. Supreme Court defended the legality of civilians carrying arms outside the home in his majority judgment.
Pistol, it can become a short-barreled rifle, and then is subject under the National Firearms Act. That's what you're saying.
Dettelbach is the director of ATF. You do agree with President Biden?
And the implementation of your rule, did Congress pass a law? What changed?
That are not designed and intended to be shouldered would be classified and not covered.
The constitutional right to keep and bear arms in public for the purpose of self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees, he wrote. There are no other constitutional rights that a person can exercise only after proving to government officials that they have a specific need, as far as we are aware. Thomas argued that since concealed carry constituted a constitutional right, it wasn't proper to judge the legality of armed legislation using the two-part test, which was the method used by lower courts for the preceding 10 years. The first component of this test determines whether it is reasonable to perceive the law in question to be at odds with the Second Amendment. If that bar is cleared, the second stage of the test entails a judge applying means-end scrutiny to balance the state's policy goals against the right to self-defense. Although Thomas acknowledged the limited legitimacy of shall-issue regulations, he also recognized that state and municipal authorities could limit the right to bear arms by taking reasonable precautions like background checks. It didn't take long for that latitude to be tested in New York. Congressional response. If pundits and government officials anticipated that there would be other incidents after Bruen, it is logical to conclude that they did so in anticipation of a licensing paradigm that would permit more dangerous people to carry an arm in more high-risk situations. Leaving aside the issue of license delays, the government's response to Bruen has been so comprehensive that those projections now seem glaringly incorrect. Although the Bruen ruling sparked a wave of outrage, Albany's response was undoubtedly the strongest. In order to close as many of the regulatory gaps left by the Bruen decision as possible, Governor Kathy Hochul called an extraordinary session of the state legislature on July 1, just 1 week following the U.S. Supreme Court's declaration. Hochul gave the Concealed Carry Improvement Act his assent on that same day. The law expanded the requirements for a concealed carry permit, among other things, by requiring 4 character references, firearm safety training, arm range testing, an in-person interview, evaluation of the applicant's past and present social media profiles from the previous 3 years, as well as conventional criminal background checks. The Concealed Carry Improvement Act also broadened the criteria for applicants to the concealed carry program, excluding those with a history of aggressive behavior, misdemeanor convictions for attack, armed possession, or menacing misdemeanor convictions related to alcohol, such as driving under the influence, recent drug treatment, and involuntary commitment to a Department of Mental Health facility. The list of sensitive places where otherwise lawfully armed people were not permitted to carry arms included places of worship, educational institutions, courthouses, federal, state, and local government buildings, polling places, public transportation, including subways and buses, health and medical facilities, entertainment venues, shelters, including homeless and domestic crime shelters, and daycare centers.
Some liability exemption for their COVID vaccines, right?
I actually am not familiar with vaccines.
Well, I've got here the actual original brace that this letter was responsive to.
Again, I think the president has given numerous different times he's talked about this provision. So I want to check. Our position on that is in briefs, but that's a different provision of the act.
When taken as a whole, These regulatory changes limit the options for lawful armed possession in New York City to a degree that ostensibly harkens back to the time before Bruin. A flurry of opposing forces have made it more difficult to legally own an arm in New York, despite Bruin's efforts to make it easier. The American arms debate reached a turning point last spring, and analyzing the Bruin decision's effects on armed crime without also acknowledging the historic adoption of armed control legislation displays a complete ignorance of the complexity of the problem. Since the May 14 racial mass incident at a Buffalo grocery store, there have been concerted efforts at the state and federal levels to reduce armed crime. These efforts began even before the Bruin ruling was announced. An even bigger loss of life occurred in Uvalde, Texas on May 24, while the country continued to mourn when 19 kids and 2 instructors were slayed at Robb Elementary School. A groundswell of support for stricter armed laws resulted from both incidents. A June 2022 survey found that public support for tightening armed laws reached its highest level in a decade in the weeks after those 2 incidents. Therefore, it was not surprising that the bipartisan Safer Communities Act, the first significant piece of armed legislation to be voted by Congress since the 1994 attack weapon prohibition, was likewise passed in June 2022. This historic federal law, a rare example of bipartisan cooperation, increased funding for mental health services, improved background checks for buyers of arms under the age of 21, expanded the need for sellers to have a federal sales license, and prohibited people with misdemeanor convictions for domestic issues from owning arms. For certain people, Bruin may have eased restrictions on hand-arm availability, but overall, last summer was far from a change toward easier access to arms in New York and the rest of the nation. Legal difficulties. Naturally, the Hochul Concealed Carry Improvement Act was quickly challenged in lower courts after becoming a law. The main complaint was that the act placed tight restrictions on the ability to publicly carry, which had been upheld in Bruin. Arm Owners of America filed a lawsuit, Antonyuk v. Bruin, on July 11 to challenge a law that required prospective concealed carry licenses to submit a list of all their social media accounts as part of the standard background check process, in addition to the traditional requirement that applicants provide 4 personal references. The complaint also challenged the law's new good moral character criterion, which arm rights activists viewed as a blatantly obvious and equally unlawful replacement for the Sullivan Act's proper cause component. Judge Glenn Sotheby of the U.S. District Court rejected the case on August 31 on the grounds that the group lacked standing. Ivan Antonyuk of Arm Owners of America filed a second lawsuit, Antonyuk v. Hochul, on September 20 with the same goal of overturning the statute, but this time naming a wider range of defendants, including Hochul, numerous district attorneys, and regional licensing organizations.
And Mr. Bosco, I think before this committee, said that people were using stabilizing braces in ways that he hadn't anticipated. Right, the Sixth Circuit, I think, ruled yesterday. A panel of the Sixth Circuit, there's a prior en banc, and what I'm saying is...
Just answer this question. As you interpret the statute, I assume you're familiar with the statute.
You're not exempting the same brace that you gave this letter to.
On October 6, Sotheby granted the plaintiffs a temporary restraining order, stopping the application of several significant legal measures, such as the ban on carrying hand-arms in public places like Times Square and the subways. However, this temporary restraining order was overturned by the Second U.S. Circuit Court of Appeals after only 1 week. On January 11, the Supreme Court rejected Antonyuk v. Negrelli, an urgent application to lift the Second U.S. Circuit stay, allowing the state to continue enforcing the parts of the legislation that Sotheby found to be unconstitutional. But as Thomas and Samuel Alito of the Supreme Court explained, they decided against granting Antonyuk's motion out of respect for the Second Circuit's procedures in managing its own docket, rather than expressing any view on the merits of the case. Supreme Court involvement is still conceivable. Bruin's influence. The real effects of Bruin are still unknown because the Concealed Carry Improvement Act is still in place. Has the choice increased the risk of armed crime for New Yorkers? Will it increase their vulnerability later on? The frequency of incidents has a wide range of legal and societal correlates, much like other types of crime. It's also impossible to directly link a specific policy or law to a crime, as with all other sorts of crime. The number of incidents is affected by a plethora of factors, including arm restrictions, policing strategies, reporting techniques, weather, and unemployment rates. Theoretically, the fact that most New Yorkers still find it extremely challenging to obtain an arm explains why Bruen did not result in a large rise in armed crime. The legislative responses following Bruen were prompt, powerful, and all-encompassing. As a result, New York does not resemble the common holsters found in the Wild West. Even if it weren't incorrect to attribute changes in armed crime to a particular law or court case, the downward trend implies that Bruen's influence on armed crime was much more nuanced than its loud critics initially believed. That's all for this video, folks. See you next time.